Welcome to the second session in our webinar series on reform of the ABA Model Procurement Code. Full information on this webinar series is available at publicprocurementinternational.com. My name is Chris Eukins. I'm a professor in the Government Procurement Law program at George Washington University Law School. The opening session of this series earlier this week gave an introduction to the Model Procurement Code, the MPC, and we discussed potential areas of reform of the code, which hasn't been updated since 2000. We were joined by two senior procurement attorneys from South Carolina, Dixon Robertson and Keith McCook. Dixon is a reporter on the ongoing initiative to update the Model Procurement Code. That earlier session is available on the program page at publicprocurementinternational.com and on the YouTube page for the GW Law Government Procurement Law program. Our featured guest this evening is Scott Scheffler of the Felsman Tucker firm in Washington, D.C. Scott is a graduate of our program at GW, and he co-teaches a course in grants law with us. He has a wonderful job as a teacher, and he's a cherished part of the program. In his private practice, Scott advises clients on matters of federal grants law, government contract law, healthcare, and education law. He is, in fact, one of the very few lawyers in the country who can bridge between both procurement and grants law, and he heads the government contracts practice at Felsman Tucker. Prior to joining that firm, Scott practiced with the U.S. Navy Office of General Counsel, advising on government contracts matters and government investigations. Before that, Scott was an officer in the Navy Judge Advocate General's Corps. We're very grateful that Scott can join us this evening. Tonight, Scott will be discussing the Office of Management and Budget OMB grants guidance in detail as it relates to procurement. That guidance directs federal grantees on how they should conduct procurement using federal grants funds. Historically, a core role of the Model Procurement Code has been as a model for federal grantees. If those grantees followed the Model Procurement Code when they procured, they could be confident that they complied with the federal government's guidance for grantees. That's no longer true, as the OMB grants guidance has been substantially overhauled since the MPC was most recently updated in 2000. The reform of the MPC will therefore likely focus first on bringing the MPC up to date with the OMB grants guidance we'll be discussing this evening. Scott will describe the grants guidance in detail, and on Tuesday, this coming Tuesday, we'll be joined by Yolanda Williams, who will discuss the gap analysis, what needs to be reformed in the MPC to conform it to the grants guidance. With that, I'll turn it over to Scott.
All right, well, thank you. Thank you for this very kind introduction as well. I'm going to have to shorten the bio that I have on our webpage. I appreciate everyone indulging it. Thank you for having me. I think it's a very, I will tell you, so I practice with the federal procurement standards on a regular basis. I practice in the procurement system on a regular basis. I was not aware until we talked about this particular presentation that one of the goals of the update of the Model Procurement Code was to conform it to the federal procurement standards. And I think that's actually, from a background standpoint, before we get into the details, is interesting in one other respect. And that's that historically, if you look at the statutory framework that authorizes particular sections, I'll say, or portions of the federal government to issue policy, and you read what the statutes say, OFPP, the Office of Federal Procurement Policy, is responsible for the procurement standards that apply to grantees. I have heard unofficially through the grapevine, now I know I'm saying this in a recorded webinar, that really OFFM, the Office of Federal Financial Management, the office that manages all other aspects of the uniform guidance, has as a practical matter taken over the procurement standards as well. So it's interesting. I wonder if this will also be a place, if there's an emphasis in the Model Procurement Code on conforming to the uniform guidance, I wonder whether this will be an opportunity for OFPP to become, or maybe remain or become more active in setting the procurement standards again. Certainly if there are those who are involved in Washington listening to this that have an ear with OFPP, I think that would be a good thing. So to the topic at hand. So I've got a couple of administrative things here. Please, with the slides, I encourage everyone to use them as for their own background. Write on them, keep them, hand them to your colleagues. Just don't post them on the internet, please. Except, of course, Chris, to the extent that they're being used for this webinar, whatever you need, of course, please do. So I want to talk about the big picture context. What I'm going to try to do in our next 2 hours, and the more discussion we have, the better. So I love this stuff. Kind of a geek on the grant stuff and on the procurement stuff. But one of the things I think Chris mentioned this is I co-teach the grant law class in GW's procurement program. And so I want to talk about kind of the big picture framework, because I think that's really useful before getting into the specific rules. But personally, I think it's better if we have dialogue. So if anyone has questions about why things are the way they are or how this interrelates to the Model Procurement Code, please pose them. So big picture universe, why there even are federal procurement standards, why the federal procurement standards matter at the state and local level, I think is best understood by looking first at the broader framework of federal involvement in state and local activities. And so what I think a picture can be worth 1,000 words. And so you see before you, the slide that you have in front of you, this sort of diagram really reflects what the vast majority of federal activity looks like. And there's two main systems, and you're familiar with these systems, I suspect most of you, two main systems through which the federal agencies, and really Congress in the background, implement federal policy and federal programs. Procurement attorneys spend most of their time typically in the world of the FAR, right? The Federal Acquisition Regulation, the FAR-based contract system, right? So we've got a handful of statutes, but most of our life is governed by these direct agency procurements and then the subcontracts that the prime contractors enter into under those contracts. So the FAR-based procurement system. That's about, and COVID has skewed this, but I'd say that's about 650. I think, Chris, you probably have the most recent numbers. $650 million a year if we disregard COVID.
$660 billion.
Billion, yes. On the financial assistance side of the ledger, so to speak, ignoring the COVID funding, which puts this into the trillions, but ignoring the COVID funding, on the financial assistance side of the house, federal grants and cooperative agreements that federal agencies issue with the authorization of Congress to state, local governments, and private entities, mostly private nonprofit entities, universities, other nonprofits, is in the area of $700 to $750 billion a year. That's a little bit skewed in the sense that Medicaid is a grant program, and so about $350 billion of the number I just threw out is actually just Medicaid. But nonetheless, there's a huge investment every year by the federal government in activities that take place across the country that are actually carried out by state, local governments, and generally speaking, nonprofit, but private parties. And within this system, in the procurement contract world, right, generally speaking, what the government is doing is it wants to acquire goods or services that it's going to consume and carrying out its own mission. It solicits the proposals, it enters into the contracts, and it pays for a deliverable. By comparison, in the financial assistance world, each and every program that Congress that is funded through the financial assistance system has its own authorizing act. It has, in many cases, they will have their own special rules, but each program, whether it's social services, infrastructure, scientific research, etc., through these programs, Congress will enact an authorizing statute. And then the individual agencies will year over year issue the funds to the non-federal partners, and the non-federal partners will implement the programs. The majority of that funding goes to state and local governments. And as that money goes to the state and local governments, it comes with many, many, many strings attached. And it's within those strings that attach that exist the federal procurement standards, rules on how, when a grant recipient or a cooperative agreement recipient uses those dollars to enter into contracts with other parties so that they can acquire the goods and services they need to carry out those federal programs, the strings establish baseline rules that they have to follow in their procurement systems. And so to take this back to what Chris was talking about with respect to the Model Procurement Code, if you think, okay, about $750 billion a year, the main recipients of that being state and local governments, strings attached to procurement for those, well, and we're going to talk about this actually, local governments, but in a way state governments, but not as directly. If some of the key rules pertain to procurement, then you can imagine about 20 to 30% of procurements that are federally funded are potentially subject to these additional rules. So it makes a lot of sense to harmonize the two systems. We're going to talk in a little bit about the fact that actually with the uniform guidance, states were accepted from most of these rules. And so that changes the calculus a bit with respect to the Model Procurement Code. But I think the reason states were accepted from those rules actually is another reason that it makes sense to harmonize them. So I'll make sense out of that as we work our way through. So in terms of, again, sort of the big picture system, before we get into specifically to the procurement standards, when we're talking about the rules that attach through federal funds, one of the things that I want to impart or want to convey, and we could talk actually for an entire hour just about this, but I won't, is the scope of power that the federal government has when it attaches the strings to the funds that it makes available to state and local governments and also private parties. I'm going to talk mostly in terms of state and local governments, just given the context of the presentation today. Since about 1930, really 1937, there were a couple of Supreme Court cases that were actually part of the switch in time to save nine back during the Great Depression, where the Supreme Court concluded that under the spending clause of the Constitution, the Congress had virtually unlimited authority to impose conditions on the funds that it makes available to non-federal partners, so states and local governments included. If you want to accept the funds, you have to accept the rules that accompany the funds. There are some exceptions to that. They're becoming more pronounced, I'd say, in the last 5 years. The exceptions have existed for a long time. It was just that they were never, courts would look at the exceptions and say, well, they don't apply here to every single case. And I'd say the last 5 years, the exceptions have been more frequently found to actually apply to cases. But by and large, the starting point in thinking about, well, what can the federal government do when it attaches conditions to funds that it makes available for these grant programs? The starting point is whatever it wants. It's whatever it wants unless there's a couple of narrow exceptions that apply. And so it's a really, really broad federal power to set policy in whatever direction it wants. This is important with procurement because the federal government can actually say, look, certainly within its discretion is to say, with respect to procurement, when you're spending our dollars, we expect you to follow certain procedures and meet certain baseline standards. And so the authority is there. So it truly becomes a question of whether they should, not whether they can. So the conversation around the model, things like the Model Procurement Code, the federal procurement standards, become more relevant. In terms of how the system is actually implemented, and this is more of a just know your way around the system piece. So Congress has a tremendous amount of authority. And how it exercises that authority, the real cornerstone of this system, if you're new to the federal financial assistance system and you're thinking, well, how do I get my arms around how it works? As of about, it was the end of 2014. So really for grants awarded after December 26, 2014. So really we're talking 2015, beginning of 2015. Prior to that, there were a series of circulars that were implemented by the Office of Management and Budget. And those circulars established administrative standards, administrative requirements, cost principles, and then audit requirements for federal awards. As of beginning of 2015, all of those circulars were consolidated into a single set of regulations. And when I say single set of regulations, it's actually two, because HHS implemented their own version, which I'll talk about. That set of regulations is called the Uniform Guidance, or the Uniform Administrative Requirements, Cost Principles, and Audit Requirements for Federal Awards. And so those rules, as they existed in the OMB circulars that predated the Uniform Guidance, have been essentially the same since the late 1960s. They've evolved glacially over that time. And then when the Uniform Guidance came about in 2015, it was simply a recodification of the existing rules. Language was tweaked, but the existing rules for the most part were retained. I'll talk about one exception in a little bit with procurement where where states were accepted. But by and large, the administrative requirements that applied to state and local governments just happened that have been imposed by the Uniform Guidance, by the circulars that preceded it, just haven't changed in ages. That's important for two reasons. One, if you're looking at, well, what's the expectation of state and local governments from a federal-wide or a nationwide procurement standpoint, the procurement standards are very useful in that respect. It's also important in the sense that because Congress has so much power to tweak programs and add new requirements, as Congress does that, even though the statutes trump the regs, when they're operating, when they're actually enacting legislation on a program by program basis, they're doing it within the framework and against the backdrop of the uniform guidance. So in this sense, even though the statutes are, of course, in our legal system, will govern over the regs, the uniform guidance really has the premier place in the system for setting the rules. Because even when Congress acts, it's thinking about the uniform guidance. Now, I mentioned there's two sets of rules, and then Chris, I see you've got a question or a comment.
Yeah, just have a question, Scott. There was a piece in the Times that the Trump campaign is already, folks associated with the Trump campaign are already coming up with approaches that would strengthen the role of the executive in the federal government. Do you think that the guidance with regards to the procurement guidance, for example, would get stronger? We'd have more force if a Trump administration was pulling power back into the White House?
Well, it's an interesting question in the sense that the White House, in my experience in the grant system, on a day-to-day basis, doesn't impact that much. And what I mean by that is that they establish the government-wide standards, but that it really is at the individual agency level that the standards are being implemented. And so one of the things we find to be a challenge across the government and across different agencies is that even though the words and the regs are the same, agency to agency, the way that they're implemented is very different. So one agency's perfectly acceptable sole source justification is very different from another agency's perfectly acceptable sole source justification. It's a lot easier to do a sole source in the context of a social service program than it is, for example, before FEMA. FEMA hates sole source. They're very prescriptive guidance on sole source, very limited time periods for sole source. So would an administration that desires to have more power reside in the White House have an impact? I don't think so. And I think it's because of the way that the agency system is set up. It's just too hard to do it. There's actually kind of a common theme, right, in the debate in the country presently. I think comparatively where you'll see this, and we're going to talk about it a little bit, is in the BABA context, so the Build America, Buy America context. The White House has said, right, there's an executive order, there's an entirely new office within OMB called the Made in America office, and they're supposed to be reviewing all of the waivers and supposed to be issuing guidance. Informally, I have heard that while they have a lot of meetings with the various agencies that have infrastructure programs, there's not a whole lot of sort of clear prescriptive guidance coming out. And so it's just very hard to wrangle the agencies at the individual program level. And I'll say my personal experience on the government side was the agency wants so much to just accomplish the mission, to just do whatever it is that they're contracting to do or issuing financial assistance to do, that those higher level policy considerations are a bit sort of a nuisance more than something that's embraced. And so I don't know. I don't think it'll make that much of a difference. I was going to mention, you'll see here the reference to 45 CFR Part 75, just for purposes of clearly laying out the system. Every agency except HHS adopted 2 CFR Part 200 as its version of the uniform guidance. HHS adopted the same standards, but reissued them in full text at 45 CFR Part 75 with minor variations. None of those impact what we're talking about. But if you're talking HHS, or if you mostly deal with the health and human services sector, the healthcare sector in particular, that's really what you're going to bump into when you're talking about the uniform guidance. But most people are talking about 2 CFR Part 200. And then something I already mentioned, but you can kind of see it here on this pyramid, is that even though we have this unified system, every agency has its own approach to implementing the system. And regulatory text, as I think probably everybody who's participating in this webinar has encountered, regulatory text can be interpreted very differently agency to agency. And when you don't have a really detailed governing regulation like the FAR, that is more likely to happen than when you have that detailed governing regulation. The uniform guidance is very much a principles-based system as opposed to a rules-based system. There are a lot of rules in the uniform guidance, but if you were to print out the uniform guidance and put a copy of it on your desk, it's maybe this thick as compared to the FAR, which I suspect many of you have on your desk, which you print it out and 6-point font, tissue thin paper, and it's in fact, I probably have a copy of it in this room somewhere. It's this thick. So the uniform guidance, there's a lot more room for interpretation. And so what agencies tend to do is they interpret it through agency-wide policy guidance documents, the HHS grants policy statement, the NIH grants policy statement. NSF has something that they call the PAPG. DoD has really detailed standard terms and conditions for research awards that operate like a guidance document, and so on. Most agencies have that are significant grant-making agencies have a robust implementing policy guide. DOJ has something that they call their financial management guide. And so that's where you can find a lot of additional detail, such as, well, what's an adequate sole source, justification for this particular agency, and it'll vary agency to agency. So within this broader system, right, when we're thinking about, well, how does the money flow and what? Oh, please.
Let me jump in here right before that last slide. Before you move on to the next topic, I thought this might be a good place to plant a question for you to answer now or at the appropriate place.
Sure.
If identical provisions in the uniform guidance are administered by agencies differently, how should we, in the process of trying to modify the model code to implement that policy, address the disparity of interpretations? So this is probably not a good example, but it'll at least illustrate the point. The federal government has rules, I suspect, like the states do, that govern conflicts of interest that individual employees may have. The federal government has rules on personal conflicts of interest by employees of contractors, which I dare say most states do not. And the federal government has a whole set of rules on organizational conflicts of interest, which I dare say most state agencies do not. Most states don't. So when you have this generic reference in the uniform guidance to conflicts of interest, how should we resolve, well, does that mean the same thing to all state agencies, and which set of conflicts are they talking about?
So I think there's a really interesting preliminary question in that, which is, do you want to? So when you're setting out a set of principles or standards that you desire everyone to adopt, to set at least sort of a minimum baseline, or at least to sort of establish a certain culture, how prescriptive do you want them to be, right? Do you want every agency's OCI rules to be the same? Or do you want every state to think about OCI and implement some sort of mitigating measures or some sort of regime of mitigating measures? I don't know from a policy standpoint which is a better answer. I will tell you, I tend toward, as a personal bias, I tend to think that a standard that sets a floor and creates a culture is better than a really prescriptive individualized standard. And that's really more what the uniform guidance does, is it sets standards for expectations on behavior, culture, and basic minimum standards, and then leaves a lot of the operationalizing to the individual recipients. I think that tends to be a good way to do it in a large, diverse country. If to the sort of the question of, well, what if that's not what we want to do? How do we avoid it? Simply issue more prescriptive standards, which can be done. I mean, that's what the FAR is. It just simply begs the question of, do we want to take the power of discretion away from the implementers? And we'll talk about, by the way, OCI in a little bit. So in terms of this system, where we're at when we're talking about the federal procurement standards is, so we have the federal agency makes the award to the state or local government or nonprofit entity, sometimes for-profits as well. And then the financial assistance recipient is actually able to make sub-grants and able to enter into procurement relationships. And there's a distinction between the two, but for purposes of today's discussion, let's say sub-grants are, I want to take something of value that I have as the grantee, some of the grant funds, and convey those to another entity that's a lot like me, or that's another community-based type entity to help me carry out this project. Usually this is social service projects or basic research, so it's another university. And I'm going to take some of those funds and convey them to this other party to bring them into the scope of my federally funded project and we'll work together as partners, and I'll flow down all the terms and conditions of the grant to them. That's a sub-grant. It's not what we're talking about today. The other side of sort of this decision tree for the grantee is, I'd like to acquire goods or services that I, the grantee or cooperative agreement holder, will consume in carrying out my mission, right? The thing that I'm doing that the federal government likes, that they're helping to, that they're participating in by funding it, sometimes also providing in-kind support, but generally cash, right? Funding it. I use those funds to go out and purchase goods or services that I'll consume in the competitive marketplace that'll help me to carry out those activities. That's where we're in the contract relationship. There are rules around sub-grant relationships. They're set forth in the uniform guidance, and they describe what grantees are expected to do in those relationships. Generally speaking, and I won't go into this too much because it's not the purpose of today's discussion. Generally speaking, it's a risk mitigation regime. You're bringing someone else into your project. That other legal entity is a separate legal entity. So just like we expect you, the grantee, to have internal controls to provide a reasonable assurance that you're managing your award in compliance with federal terms and conditions. Now, sub-grantee is brought into the project. They're a separate legal entity. They're not subject to your policies. So you have an agreement with them, the sub-award agreement, whereby you create the right to oversee and manage them, disallow costs, et cetera, to provide you a reasonable assurance they perform in compliance with the terms and conditions of the award. That's sub-grants. We're going to talk about procurement relationships. Go ahead, Chris.
In choosing between a sub-grant or sub-award versus a contract, does the grantee have guidance in that regard, or is it just completely discretionary?
They do have guidance. In fact, so at 200.331, there are factors, and the way that the regs are laid out is that there's a bias within the grant, the financial assist, the uniform guidance, the financial assistance system regulations. There is a bias in favor of reaching one of those two things. There's this sort of assumption that there's no other possible relationships in the world besides sub-grants and contracts. And that's not really true. There are other types of relationships that you could have, but I think it is fair to say 90%, 95% of your relationships are going to be outside of employment relationships, are going to be sub-grants and contracts. And so at 200.331, there are factors that you're supposed to consider in deciding what type of relationship it is that you're entering into, or if you're looking at the agreement after the fact. These factors are actually really written for auditors originally. They were pulled out of the audit section of the regs into the administrative requirements section of the regs when the uniform guidance was issued. And so actually they're written more to be looking at an agreement that already exists and trying to put it in one of the buckets, which again is a separate problem, because once the agreement exists and you're administering it, the requirements that apply to sub-grants, and I'll talk about the factors in a minute, the requirements that apply to sub-grants and the requirements that apply to procurement contracts are very different, and they're really not compatible. So the way the regs are set out is factors for contractors are set out in 331 subparagraph A, factors that are typically present for subawards are in B, and then C says, however, not all factors will be present in all cases. And so to that extent, you as the grantee have discretion in classifying the relationship. So there is in fact a lot of discretion. The reality is the factors that are described in the regulations are only helpful in obvious scenarios. If you go to Staples and buy paper, the factors are useful, but you didn't need them in the first place because you're buying paper, right? It's not a sub-grant. If you are making funds from your federal award available, they say it's a federal award to you as a, let's say you're an AmeriCorps recipient. So you receive funds to encourage certain volunteering opportunities. And you take some of those funds and you sub-award them to another entity that looks like you, a community-based nonprofit down the street in your local area. And it looks, right, the relationship you establish looks just like your relationship with your funder. That's obviously a sub-grant. All the factors that you'd be looking at are present. Where you get into an area that there's a lot of discretion is service contracts. So service contracts, you could structure an arrangement. If you think about healthcare, right? Imagine a scenario, and actually this, to your question, I don't know whether there might be some utility in the Model Procurement Code addressing this distinction. And the reason I'll come back to that point, I'm going to make a note, but a lot of states don't do a good job of making this distinction in their internal procurement statutes or regulations. So if I don't come back to that, remind me. I'm gonna make a note.
Well, the reason I'm asking is Keith's question, which is if we write the MPC too tight, make it very prescriptive, are in this discretionary gray zone, are we in essence driving the federal grantees towards subawards, towards subgrants, because they'll want to avoid the highly prescriptive requirements of the MPC if they've adopted it?
So I don't think so, and I'll tell you why, but I'll tell you why I think it's still important to be clear about this. So what happens is I call it the sort of the service contract problem. Imagine a scenario where you're a recipient. I'm going to use a nonprofit example here to make my point, but you could see this happening for local governments potentially as well. Less so state governments, but certainly local governments, and they're huge actors in this space. But let's say you're a nonprofit healthcare provider, and you receive an award to provide healthcare services. Let's say HIV services. Let's say it's a Ryan White grant, Ryan White Part C grant. You receive an award to provide healthcare services to people living with HIV or AIDS. And so that's what the funds are for. You could pretty much spend them for any allowable costs, meaning anything consistent with the cost principles for providing those types of healthcare services and support services to people who qualify under that sort of broad definition. It's a little more specific than that. And let's say you decide, you know what, I want to do more, and I'd like to apply for more grant funds in the next year, but I'm not sure how I want to expand my capacity. You really have two legitimate options, right? You could say, well, I want to bring another partner that looks like my organization. They'd be eligible to be a Ryan White recipient, and they're a similar organization to mine. I want to bring them into my project by making them a subrecipient. Or you could say, you know what, I just want to pay them some fixed amount per month or some fixed amount per hour per physician or per visit, per patient seen. And they'll just see the patients at their facility. I'll do the billing for the services, seeking reimbursement, but I just want to pay them like a unit price. You could set up the relationship either way. If you take some of your federal funds and make a subaward to that other entity, you have to flow down all the terms and conditions of the federal award into that arrangement, but you don't have to compete it. You just have to get prior approval from your awarding agency to make the subaward. But then on the back end, there's a whole lot of management of the relationship that's required. So to the point I was making earlier, subawards are very much a risk management endeavor under the regulations. And those are the rules that are going to apply. By comparison, if you don't care what local physicians are seeing those patients, you just want to expand your capacity and you want to bring more capacity into your system, and you want the relationship on the back end to be easy to manage. You want to just pay, let's say, $150 per patient seen, then that's going to be a procurement relationship. And so the rules that will apply there, the ones we're going to be talking about at length as we continue through this discussion, are that you'll have to have competition in the award of the contract. And so what drives this thought process for a grantee that could go one way or the other, generally speaking, is the competition in the award of the contract and having to recompete it eventually more of a hassle to me because I know who I want to work with and I just want to work with them? Or is the management of the relationship on the back end more of a hassle? I would say for most nonprofits, the management of the relationship on the back end is more of a hassle than the competition up front. I don't know for a state or local government which would be considered more of a hassle. The reason that the distinction exists between the subawards and the contracts and the way that the current distinction, what we just talked through between the nature of a subgrant and the nature of a contract, is actually it's in the regs in the uniform guidance, and it came out of the A133, which was the audit standards that applied to grantees. But really, where it originated was something called the Federal Grant and Cooperative Agreement Act of 1977. The Federal Grant and Cooperative Agreement Act of 1977 was actually an outgrowth of the Commission on Government Procurement's review of what federal agencies were doing in the government contract context back in the 60s. And the complaint was that federal agencies were using grants to get around competition. And so the Federal Grant and Cooperative Agreement Act ostensibly was to solve that problem by saying only use grants in certain situations and use procurement contracts in certain situations. It doesn't really have the same effect today as it used to, because generally speaking, at the federal agency level, when Congress implements these programs, it'll say just make grants. So you don't have a lot of distinction at the agency level. You just make the grant because that's what Congress said. But that concept actually is relevant in terms of at the sub-grantee level. If you're a state government, you may want to make grants to just not have to deal with competition.
So Scott, one of the things that you mentioned that I think is interesting for the model code project, I don't believe, it's been so long since I looked at the model regulations. I don't believe the model regulations address this. But the model code actually has a definition of procurement and grant. And although it never defines a procurement is not a grant and vice versa, it clearly sets up this dichotomy. And that is useful in the state context repeatedly, and has gotten a fair bit of attention. And it'll be, an example would be an agency decides to do something, their statutory authority to do it doesn't clearly make it a grant. So you might have money flowed down to businesses that provide housing for wards of the state. Well, that might be a grant, depending upon how the legislature wrote it or how the program is administered, what the expectations are. It might be a procurement. And we've used that definition, but having some guidance or comments or perhaps model regulations that incorporated the factors from the uniform grant guidance would harmonize the two and provide a little more guidance to the agencies in the state as they navigate that. So it's interesting to see that connection between the two. And I thought I would draw that out and point out that the model code has its own definition.
I think that's a great point. I would encourage, if you were to do that, if you were to adopt the uniform guidance factors, I would encourage you to improve upon them, because they're really not all that helpful except in the obvious scenarios. And there are two respects in which they're not, they could be improved. The first is that in real life, this is not a factor, but one of the things that really drives the decision-making process when you're evaluating which way to go is the payment relationship. If what you want is or what you have before you is a fixed price arrangement, any arrangement that looks like it has a profit component, it's very hard to conceive of that as a grant. There are fixed amount awards and fixed amount subawards, but they're still very rare. There's a couple of programs where they're common, but mostly they're very rare. And that's not a factor that's stated, which is sort of surprising. And then the second factor that tends to be really influential is what's the nature of the other entity? Is it in fact an eligible entity to receive a subaward? So if you're entering into a relationship in a federal program, especially a social services program with a for-profit, is that for-profit actually eligible to be a subgrantee? And so I think those would be areas of improvement. An area that is sort of addressed in the factors, but not well addressed, is the nature of the underlying work, whether it seems to be more programmatic in nature or whether it seems to be more administrative in nature. I have seen federal agencies, and in fact, if memory serves, I think the most aggressively I've seen this asserted was HUD, telling, in fact, in this case, I think it was a state, it could have been a county government, but I believe it was a state government, that because the nature of the underlying work that they were bringing another nonprofit in to do they basically said, we understand that you brought them in as a project partner and they're a nonprofit and they're not making any profit on this, it's all cost reimbursement, but because the work they're doing is administrative in nature, we just don't feel like it's a subaward. And that I've only seen it aggressively pushed in that one context, but it's always lurking in the background. If the work feels more administrative, like managing the award, managing financial management issues, things of that nature, as opposed to doing the programmatic work, seeing patients, writing reports that are programmatically substantive, et cetera, you'll tend to get pushed toward contractor relationship, even though that's not really a factor. And by the way, in the case that I mentioned, actually HUD backed off on it because it's not really a distinction, but it is lurking in the background. It does tend to influence the decisions. So we've talked now, and Keith, thank you, because I think those are really important points. We've talked about the broader scheme of where procurement contracts live and what states and local governments might be thinking about within the financial assistance system that we'd be trying to harmonize with the Model Procurement Code, or that exists that you'd be trying to harmonize the Model Procurement Code with. And so where the federal procurement standards, the rules, the primary rules around entering into contracts arise is in that sort of band of relationships that are the contractor relationships, the historically called vendor relationships that are funded with federal dollars or with program income or matching funds under a federal award. And where on the sub-grant side of the ledger or side of the world, side of the system, it's a risk management relationship. All the rules around procurement, almost all the rules around procurement, really are focused on competition in the award of the contract. The uniform guidance procurement standards, if you had to just distill them to their basic essence, it's best value. It's just like the FAR, the concept of best value. And in fact, I really believe, I don't have any evidence of this, but I really believe that OFPP, back when the earlier iterations were developed of the federal procurement standards that are now sort of modified, but still largely in existence, I have a strong feeling that OFPP was directly involved. Maybe they still are, but like I said, I've heard through the grapevine that they are less so. So this is actually, so I want to highlight, I'm not, so obviously I have a relationship with GW. I actually took Schooner's class years and years ago. And this article that he wrote, the Desiderata, I use this all the time with grantees to talk about why are we doing the things that are in the federal procurement standards. And I highlight that because this article was written about the FAR, but the same exact principles are the principles that drive, especially the three primary principles that are outlined in Stephen Schooner's Desiderata, are the fundamental principles that drive the federal procurement standards. So in that sense, the Model Procurement Code and the federal procurement standards are already harmonized to a degree. But competition, the notion that if you get competition in the award of the contract, then that will root out in an efficient way most of the evils in the system. It'll root out fraud and waste. It'll increase your likelihood of best value. It'll root out what I would call, I guess waste is the best term for it, but sort of it wasn't my money. The issue of it's not my money, so I don't care necessarily if I get best value, I'll spend more because the federal government will give me more, right? That's what the government's worried about. They want to see best value. Doesn't mean low price technically acceptable, right? Doesn't mean you have to go with the lowest price offerer. And I'll talk about specifically these competition rules, but the idea that you're seeking best value and you're seeking it through competition. Integrity, the layered onto, if you were to say, okay, well, what's the basic premise of the federal procurement standards under the uniform guidance, it's best value. Then the next piece that's layered on from a sort of regulatory strategic standpoint, a big picture standpoint, is conflict of interest rules. So there are certain baseline standards that apply from a conflict of interest standpoint. We'll talk about those. And then the last piece, this really in the regs is embodied in the competition standards, and I'll talk about those again. I'm going to go through a list of baseline competition standards that are actually set out in the regs as essentially rules, and you'll see that they're very similar to things that you find in the FAR. Transparency, what Schooner calls transparency in his article, but what I read when you read the Desiderata, he really means access in my view, which is the idea that anyone who's qualified to compete for the award should be able to compete for the award. And so we'll talk about that. But these three principles are at the heart of the uniform guidance, just like they're at the heart of the FAR. The uniform guidance really is a watered down, sort of more bare bones, principles-based version of what you find a rule for everything in the FAR. So I actually often, when I'm either talking about the federal procurement standards to a group of grantees, or if I'm talking to my clients and they say, well, what's the, how do I do X, Y, or Z? Because it's not in the regs. And I'll say, well, just do what the FAR says. Because if it's good for the goose, it's good for the gander. And if you can point to the federal acquisition regulation for what you're doing, if you want a rule, there will be a rule in the federal acquisition regulation. Just adopt it because it's a safe way to go. So, excuse me. I already talked about a lot of this. So we're going to focus on, I already said most of what's on the slide here, but what we're going to focus on as we talk about the procurement standards in particular for the next hour and 15 minutes or so with a little break in there is the applicability, because there's a big exception I keep alluding to, and we should talk about it more directly. Competition really is the key to the whole thing. Within the context of competition, there are sole sourcing standards. They're actually called non-competitive award standards. That's actually, I think it might be a better term. Documentation requirements, we'll talk about those, but perhaps not the main focus today. A prohibition on state and local geographic preferences. I think this is important when we're talking about state procurements. So we'll get into that. And then there are certain required contract terms that flow down through by virtue of the federal funding. They're not as robust as what you might think, but they are worth mentioning. And so, Chris, please go ahead.
Yes, just quickly, as you suggest, we will take a break, a 10-minute break at 7 o'clock. On this last point, Scott, do the required contract terms help frame up what contract administration will look like?
No, they do in the sense that if it's a construction contract, they do, because potentially you have Davis-Bacon, Contract Work Hours and Safety Standards Act, things of that nature, but only if Davis-Bacon is applied to that particular program by virtue of the authorizing statute or the Appropriations Act that funds the program. So for construction, sometimes, depends on the program. Otherwise, mostly no. There's a requirement to have a termination for convenience clause, and there's a requirement to have remedies for failure to perform. But everyone's already doing that. I mean, maybe not the termination for convenience clause, which gets a little bit weird in a commercial context, but everyone's already doing the other stuff. And so the idea that the government says you have to have terms and conditions in your contract that provide remedies for non-performance, well, okay, that makes sense, and it's a good requirement, but that's not the kind of thing that most entities, even relatively unsophisticated entities, need to be told. It'll be there anyway. So applicability. So, and trying to decide, I'll get to it when we get to the contract terms. The place where the required contract terms, where that stuff's becoming more important, is like the domestic preference area, the Huawei ban, all the policy stuff. And that's really what Davis-Bacon is the labor policy stuff. So every grantee is required to comply with 2 CFR 200 point. So all the procurement standards, 337 through, I think it's 335, except state governments. One of the big things that happened, and I think, Chris, you published on this at the time, one of the big things that happened with the uniform guidance is that that OMB said, look, if you're a state agency, you're required essentially to just comply with your own procurement policy. You do not have to follow the specific requirements of the federal procurement standards. So there are certain aspects of the procurement standards, some very minimal aspects that states have to comply with, and I'll highlight those as we go. But the competition standards, all the process stuff, that is what the federal government oversees with respect to local governments and non-profits and for-profits when they're using federal dollars to purchase things. The competition piece, the conflicts of interest piece, all of those rules fall within sections that don't apply to state governments. States simply have to follow their own procurement codes. Most states, I believe the reason this was done was twofold. I don't know, actually, though. I've never had the opportunity to ask anyone who knows why this was done, but I believe it was for 2 reasons. One, I think it was a nod to the fact that states are, in fact, independent sovereigns, even if in all other respects of the grant system, they don't get treated that way. And then secondarily, and more importantly, I think it's because states actually had reasonable procurement systems, responsible procurement systems that addressed most of the stuff that was in the uniform guidance to start with. Now, that second assumption, I've never gone state to state to verify. So I'd be interested if anyone disagrees. But I think because of things like the Model Procurement Code, because of efforts by NASPO, et cetera, states tend to have rules.
So Scott, I just want to ask about this last exception, which I wasn't aware of. That's a whopping exception. So any procurement done out of something in an indirect cost pool. So if you have, if I'm a nonprofit, I'm a grantee, and I have all my procurement done by my general counsel's office, which is part of an indirect cost pool, then I don't have to follow the procurement rules?
It's not who administers the procurement activity. It's whether the cost of the contract is a direct or indirect cost. So, but for example, if it's your accounting system, right? So you have an electronic financial management system, and that's just part of your overhead because it's something you contract for it year over year. You don't want to switch it, whatever. That's an indirect cost that you don't have to follow the federal procurement standards. By comparison, if you hire a consultant to help you carry out a particular research project, it doesn't matter who administers the procurement activity. What matters is that the contract for the consultant is charged as a direct cost. That's what drives the difference. So if the language here is confusing, my apologies. But it's still a whopping exception, by the way, and it's one that a lot of grantees aren't aware of. It's also one that shouldn't be in an FAQ. it should be in the regulations. It's too important to be in an FAQ. The uniform guidance is updated every 5 years. And when it was last updated, it was my view that this particular exception should have been incorporated into the regulatory text, and it hasn't been. On the other hand, the CFO Council the CFO Council is a body of OMB, and these FAQs are posted officially on the website. So I think it's very safe to rely on this. I've never seen this become a problem for any grant team. So I will say, as a public service announcement, the acting Comptroller General spoke to the National Grants Management Association conference back in April and announced to 1,300 gasps in the room that they're working on a full rewrite of the uniform guidance that they expect to publish a proposed rule on maybe late August, early September. And so we're watching that very closely because according to her, it will be similar to the existing language, but they're going to clarify it and make it easier to read so that you, quote, don't need lawyers to read the uniform guidance. In my experience, whenever agencies have clarified regulations such that you don't need lawyers to read them, you need more lawyers to read them after that. So it's expected to be a significant rewrite. And then I think they said they wanted to issue the final rule by December is what she said. So, something that one person said on the stage, or that person was the acting CFO, or Comptroller General, not Comptroller General, excuse me, the head of OFFM. So.
And Scott, I forgot to mention in the introduction, you were recently named president of the board of directors of the National Grants Management Association. Congratulations.
Oh, yeah, thank you. It's for anyone who's interested in grants information, NGMA is the place to go. All right, so baseline competition considerations. So let me talk, what I propose we do, if it's okay with you, in certain terms of timeline. And I will look up while we're on the break who the individual was that said that. I've got it somewhere. But yeah, it wasn't the Comptroller General. I misspoke, and I know you're recording this. Let me make sure I've got the right person to attribute it to, but I'll clarify after the break. What I propose we do in terms of timeline is I talk about this section, and then we break, and then we come back and talk about the competition procedures that are required under the uniform guidance for everyone but state governments. So underlying sort of baseline standards, this idea that we have minimum applicable standards to foster competition that are actually listed in the regs. Most of these you'll find at 318 and 319. I've got the references here though to the pertinent code sections. So one of the things you're required to do in every procurement, and when I say every procurement for the rest of the presentation, I really mean every procurement over $10,000. For some of these, an argument could be made that it applies for procurements under $10,000, but because the micro purchase threshold applies in the grants context, like it does in the federal procurement context, which we'll get into, for these specific rules, think over $10,000. So one of the things you're required to do when you evaluate competitive proposals, which is going to be all of your contracts over $10,000, is to evaluate price. Price has to be one of your factors. It doesn't have to be the only factor, and you don't have to make your determination based on price, but price is one of your factors. So generally speaking, you want to have an independent price estimate. There's no requirement in uniform guidance to have an independent price estimate before you enter into a procurement process. But if you have to evaluate price and you don't have an independent price estimate, it's harder to actually write that up. So you're required when you issue your solicitation, and we're going to talk about the solicitation can be informal between $10,000 and $250,000, and over $250,000 it has to be formal in the form of an RFP or an invitation for bids. But either way, if you're over $10,000, you're required to tell the potential offerers or potential quoters, the potential proposers, I'll say, what factors matter to you. So this is a lot like FAR Part 15. What factors matter to you when for the thing that you're going to buy? So let's say you're buying a vehicle. You're supposed to say, well, I'd like to buy a vehicle, and quality and price are both important to me, but quality is more important than price, right? It can be just like under the FAR. It doesn't have to be quantitative, but you do have to say the relative weighting of the factors. A lot of grantees don't do this. They don't tend to get in trouble for it, but it is in the regs. To get more specific, really best practice would be if you're talking about quality, right? Quality is more important. Well, what about quality? Do you want it to have a GPS and leather seats? Or do you just want it to never have to be repaired, right? When you're talking about a vehicle, or is it both? So that just like under FAR Part 15, you're required to convey the factors that you'll be considering in the award decision. Since it's informal between $10,000 and $250,000, it's hard to have a non-compliance problem with this in an informal procurement. But the regs are, if it's competitive, you're supposed to tell the competing offerers what their factors are. You're prohibited, just like you are under FAR Part. If I cite to the wrong part of the FAR, feel free to correct me, Chris, but no unduly, so again, I think this is FAR Part 15, no unduly restrictive criteria. So just like under the FAR, no unreasonable experience requirements, for example. So if you're a local government and you have a facility and you're hiring a contractor to do facility administration, let's say lawn care services, and you say, well, for the lawn care services, you have to have 20 years of experience doing lawn care. That's probably an unreasonably restrictive criteria. 5 years maybe makes sense. 7 years maybe makes sense. But 20 years to do lawn care is probably an excessive and unduly restrictive criteria. So just like the FAR. You're allowed to describe your desired good or service in terms of brand name. But again, just like the FAR, so this is where I kind of make the point of it really is a mini version of the FAR in terms of key principles. You're allowed to describe the thing that you're seeking, that you're soliciting in terms of brand name, but just like the FAR, it has to be brand name or equal. So the example I think that's most relevant here is back in say 2007, 2008, if what you wanted was a smartphone, it would have been perfectly reasonable if you were a local government buying smartphones to say, what I want is an iPhone or its equivalent. And just like under the FAR, you're actually required to list the salient characteristics of equivalent. So if you were back in 2007, you're buying an iPhone, you're buying a smartphone, you would say, I'd like an iPhone or its equivalent. And by equivalent, I mean that it is a handheld device that has basic web browsing capability, email connectivity, text phone, and a camera. And so brand name or equal is just like what everyone experiences under the FAR, but it's a baseline competition standard. If you just do brand name, there's a good chance you're starting to sort of wander into the world of what will probably be considered sole source or restricted source in a way that you could have a non-compliance problem. Non-compliance generally, by the way, is punished by disallowing the cost of the procurement. So you got to pay the money back, even though the money's out the door. Sole source. I think I have a slide specific to sole source circumstances. If you want to engage in a non-competitive award over $10,000, there are only 4 circumstances in which you can do so, and we'll talk about them as we work our way through the presentation after the break. Big pick, real quickly, I'll run through the list. It's available from only one source, so sounds just like FAR Part 6, right? Public exigency or emergency, sounds just like FAR Part 6. I think subpart 6.3, right? And then maybe 6.4. And then the other ones are a little bit different. You have specific approval from your funding agency to engage in the non-competitive award. Very rarely does that happen. I've only ever really seen CDC do it. And then the last one is actually very similar to FAR Part 15. You solicit from the whole wide world, but you only receive one offer. So you didn't sole source it in the sense that you only solicited from one entity, but rather it's confirmation that the non-competitive award, this is why non-competitive is a better term than sole source in this context, the non-competitive award is after you at least tried to get competitive proposals. Pre-approved vendor lists are permitted, but they can't become an unreasonable barrier to competition. So if you have a pre-approved, if you have to, for example, for construction, provide qualifications to the local government entity, recently helped a water district with this. It's fine to have a pre-approved vendor list, or I think pre-qualified is a better term to use, pre-qualified vendor list, but either that should be a list that's open throughout the year where entities can just call up the right person and try to get on it by submitting their qualifications, or it's a list that maybe 3 or 4 times a year you reopen so that people can compete to get onto the list. It can't become an unreasonable barrier to competition. That's a good example also, by the way, of a standard that you could see us, any agency to agency, state to state, et cetera, interpret a little bit differently. It's good to sort of have that cultural concept, that baseline idea of, look, pre-approved vendors can't be on lists, can't be unreasonable barriers, but exactly how you want to implement that, having a little bit of flexibility, to Keith's question from earlier. promotion of small business when possible. So there's a very soft encouragement. It's weird because the language is something to the effect of you must engage in certain activities to encourage small business participation when possible. So must when possible. Is that a must or is it a when possible? Very rarely do I see compliance problems around this. Agencies just don't assert them, most likely because of the when possible language. But there is encouragement in the regulations to engage in organization-wide measures or implement organization-wide programs to attempt to encourage small business participation by women-owned businesses, historically disadvantaged businesses, and labor surplus area concerns. So that policy consideration is in there, even though it's not a hard requirement. And then now increasingly, so we've had domestic sourcing encouragement, I would say a soft encouragement since 2020. Now with BABA for infrastructure projects, we have a really robust domestic sourcing requirement that's going to be rolled out to all federal awards pretty much. And so we'll talk about that in a minute. So I think with that, we should probably take the break and then we can come back and work our way through the rest of it after the break.
Thanks, Scott. When we reconvene at 10 past the hour.
All right,
Thank you.
and I'll get that name. I have it here somewhere.
The floor is yours, Scott.
Thank you. So what I did is I dropped into the chat. I went and I pulled the client alert that we put out that day. It was Deidre Harrison. Ms. Harrison is the deputy controller. I don't recall, I had it in my head, she may have been acting controller at the time, but she's deputy controller within OMB. So it's from an authoritative source. This is on the uniform guidance updates. So I expect, we fully expect we're going to see those. The second thing I wanted to mention when I was looking at this and thinking about NGMA is that for those who are involved in state and local procurement, about roughly, if memory serves, roughly 30% of NGMA's constituency is state agency personnel. And so this is an issue where the grants managers and the procurement professionals really do, I think, interact a lot at the state agency level. So very much including at the, we were just fortunate to have join the NGMA board one of the grants management representatives at the OMB level. It's actually called OBM in the state of Ohio. And another one of our board members is at the sort of OMB equivalent level in grants management in the state of Illinois. So the states are really active in NGMA. So competition-oriented procedures. So these are baseline rules. What we just talked through are within the uniform guidance baseline rules for everyone, actually, except for state governments. Those state governments tend to do this stuff anyhow, in setting up their procurement processes, in how they identify their, what it is that they're soliciting, how they convey the message of what it is they're soliciting to potential offerers, and then how they evaluate those offers. These are minimum baseline standards. And as you can see, right, it's a sort of an abbreviated version of FAR Parts 15 and 6. The actual mechanics of soliciting competition are set forth in 200-320. And they're relatively specific in terms of the way it's set up is very similar, again, to the federal acquisition regulation. You've got your micro purchases, you've got your simplified acquisition threshold, and then you've got your stuff that's above the simplified acquisition threshold. And so those thresholds become critical. Under the micro purchase threshold, and I want to talk a minute, I don't have a slide on this, but I want to mention a nuance on the micro purchase threshold within the grant system. The micro purchase threshold is in most instances $10,000. So for most grantees, and again, if you're a state, right, you're not subject to this piece, but if you're a local government, nonprofit, the federal procurement standards say that the micro purchase threshold is $10,000. Talk about an exception to that in a minute. Under the micro purchase threshold, the regulations are very clear. And in fact, when they were updated for Part 200 in 2020, they were made even more clear that if you're under the micro purchase threshold, you just buy what you need. The government has made the choice that the additional administrative burden of going through the competitive process, et cetera, following all the rules around competition, outweighs the benefit in rooting out fraud, waste, and abuse, the benefit in getting best value when what you're buying is under $10,000. And then I would also say one thing to keep in mind, and I think this is probably something to keep in mind from a policy standpoint in the Model Procurement Code, is that state and local governments are mostly buying commercial items. Right? In the federal acquisition regulations, we think in terms of commercial items and non-commercial items and how we need these two separate systems because no one's going to sell you commercial items if you have all the rules that are in the FAR. Well, that's fine if it's NASA and DOD and you're buying CIA, you're buying all this crazy stuff. State and local governments, nonprofits, they're just buying the same stuff that normal people buy. It's paper, it's vehicles, it might be IT systems, but they're IT systems that would qualify as commercial items. So you're already in this world of everything's a commercial item. So I think that's worth keeping in mind when thinking about procurement at the state level. In terms of below the micro purchase threshold, no competition requirement, there is a rule that you do your best to spread it around. So there's 3 gas stations in town and you've got a gas card, you use multiple gas stations. If you've got, there's multiple hardware stores in town, go to all the hardware stores when you buy the, your supplies, et cetera. Go to Office Max and Office Depot if they both still exist, and Staples. Spread it around, but no specific competition requirement. Federal agencies don't show up and say, let me see your procurement documents for micro purchases. Over $10,000, they do show up and say, let me see your file. I want to see how you procured over $10,000. And the language in the regulations is very general language. You can use informal processes. You have to get price quotes from, quote, an adequate number of qualified sources. It does not say in the regs what an adequate number of qualified sources is. Culture, custom, and practice in the grant system is that it's 3 quotes. And I like to recommend, you can make an argument for 2 quotes in some circumstances. So for example, I have dealt with an entity that says, look, I'll solicit 3, but if I only get 2 after I solicit 3, that's going to be good enough for me. But an adequate number, soliciting from at least 3, ideally getting at least 2. The language of the regs is obtain at least 3 quotes, or actually it's obtain quotes from an adequate number of qualified sources. In practice, soliciting 3 quotes, in my experience, seems to be sufficient. And so this is very much like FAR Part 13, right? It's just under the simplified acquisition threshold, 3 quotes from your local trade area. That's the process. And then over $250,000, I'll talk about in a minute, but I want to talk about the micro purchase threshold more. Over $250,000, we're going to have formal competition. This is where you get your written RFP that's widely publicized, or an invitation for bids that is advertised. And so we'll come to that in a minute. The micro purchase threshold in 2020, the regs were updated in 2 CFR Part 200, but not in 45 CFR Part 75. So when HHS did its own thing and just issued its own set of regs, a lot of us complained. We said, you know, you're setting us up now for the 2 sets of regs to diverge over time. And in fact, now we're seeing that happen, because since 2020, HHS has not substantively updated Part 75, not in any way relevant to day-to-day grant performance. They deal with policy issues that are relevant in HHS programs, but not with respect to sort of things like procurement, the day-to-day nuts and bolts. So in Part 200, one of the changes that we got in 2020 was that well, let me take a step back. All grantees that expend more than $750,000 in federal awards are required, in a fiscal year, are required to have an audit done. And they go out, it's called a single audit. They go out and they hire an independent audit firm, or if you're a state, you actually can use your state auditor. And then there's very particular rules about how the audit's conducted, what the audit report has to include, and where it's published, and all that stuff. But if you had a clean audit in that process, you are permitted under 2 CFR Part 200 to raise your micro purchase threshold to $50,000. I have not seen that done a lot. My sense is, but I don't have empirical evidence for this, my sense is that the entities that are tending to want to do that are universities, institutions of higher education, and not so much community-based nonprofits, not so much local governments. In fact, local governments tend to have potentially even lower micro purchase threshold type rules, like $5,000. State governments, I think, also can tend to have lower micro purchase threshold type rules, though that, again, doesn't interact with the uniform guidance because it's a separate system by virtue of the state exception. But technically, if you had a clean audit in your prior year, you can elect year to year to raise your micro purchase threshold, your no competition rules, all the way up to $50,000 per purchase. And that's a pretty significant micro purchase threshold. A lot of it, I think grantees don't like the idea because all you need is one finding on an audit, and it actually causes you to have to change your procurement procedures, which would be an enormous hassle, especially all the training that would entail internally. Above $250,000, this is where grantees tend to get into trouble. This is where you have formal competition requirements. It's really easy. Grantees complain. Frankly, when you tell them you've got to get 3 quotes, they'll say, oh, it's such a hassle to do competition. But 3 quotes is, I'm a little bit unsympathetic that 3 quotes is not that hard to do. I mean, contacting, especially through informal means, phone call followed up by email, it's not that hard if you're spending at least $10,000 to get 3 quotes. Formal competition is burdensome, but it's only imposed when you're spending $250,000 or more. So if the contract is expected to be at or exceed $250,000 in value. I will point out, and I think this is an important thing to consider, by the way, for the Model Procurement Code, is that the uniform guidance doesn't tell you how to calculate the thresholds. So I use what I understand to be the FAR practice, though when I go and try to find this in the regulatory language of the FAR, I think it could be clearer. And that is, you look at what's the expected total contract value over time. So if it's an IDIQ contract, you think, how much am I going to buy on this thing? And if I'm going to buy $400,000 worth of stuff on the IDIQ contract, even if my minimum is $10,000, that's going to be over $250,000. But the regulations and the uniform guides actually don't define how you calculate the threshold, and I think they should. Go ahead, Christensen.
Yeah, and in terms of when the grantee says, "Oh my God, I have to get three quotes," we spent a lot of time talking about this on the contract side. On the purpose of getting multiple proposals or multiple quotes is to get more information from the marketplace so that the buyer makes a better decision. Does you see that anywhere in the OMB guidance, that insight?
Well, I think that that's what's driving the requirement. I think it's exactly the same goal that's driving the requirement. So yes, there's not an explicit connection, but I think that's exactly what it is. And in fact, when I talk to procurement people within grantee organizations, and they say, look, it's really hard to get our people to want to get on board with the 3 quotes. We make them do it, but it's hard to convince them that this is worth their time. Because they'll tell you that it's just like when I was in the federal government, the person would come to you and they'd say, well, no, only this one thing will work. Only this, there's this one consultant that's the only one that knows how to do this. And the answer I always found to that question is the same in the grant system as it was in the federal procurement system, which is, well, maybe that's true, but we have to test the system because maybe we'll be surprised, right? Maybe there's other people out there who can do this, or maybe there are other vendors out there who can do this, even if it's like an OEM part that we need. Well, maybe there's multiple distributors that want to compete on price, especially depending on how we structure that contract over time. And it's the same in both systems. So I think the goals are the same, but the answer to the question of why, look, I know who we really want, why do I have to go through this? The answer is the same too. I mean, actually the marketplace will surprise you to everyone's benefit. So over $250,000, really, there's 2 primary means of formal competition, and they're actually spelled out in the uniform guidance. There's competitive proposals, which we call in the FAR system competitive negotiation, which I think is a better term, but that's your RFP process. So you actually write up a written RFP. And in fact, though this is an area where I think compliance is probably pretty spotty in the grant system, though no one seems to be looking at it. Technically, if you use an RFP, you're required to actually establish a written evaluation plan before you issue the RFP. It shouldn't be that much burden as a practical matter because you could take that evaluation plan and you can actually pull then the evaluation factors, et cetera, and just keep things like who the evaluators are off to the side. You could lift that right into your RFP and have a lot of your RFP drafted. But technically, you're required for an RFP to do a written evaluation plan. Then you do the written RFP. You widely publicize the RFP. Widely publicized is not defined. This is an area where I like that it's not defined in the sense that I think there should be flexibility, but I don't like that it's not defined in the sense that I constantly get the question of what it means, and it might be easier to just add a little more definition. What I tend to tell people, and what I think will work from a dispute standpoint, is if you put it on your website and you put it in the local newspaper in the section of the newspaper, at least if you're in a large metropolitan area, that's designed for contractors to put out, for buyers to put out information to contractors, you're going to be fine. And so widely publicize, and then you receive the proposals, you evaluate the proposals in accordance with the RFP, and then you make your award. There is no requirement to have a bid protest mechanism. I believe in some programs, there is a programmatic requirement in the DOT context. But what I tell grantees all the time is do not establish a bid protest mechanism. You do not want to have to deal. You're supposed to follow what the RFP says, but you don't want disappointed contractors to have the right to litigate that. Now, that's going to be different in the Model Procurement Code context, potentially. But there you're talking about governmental entities. If you're a nonprofit, I always recommend you don't want to create a right to challenge an award decision. It's just too much hassle. And there is no requirement to do that under the uniform guidance. Invitation for bids, sealed bidding, it's just like under the FAR. You should only use it when everyone's going to be competing on basic qualifications plus price. And the process is the same. You issue the invitation for bids, you get the basic statement of qualifications, you get the price proposal, you open the proposals in a public place, and you announce who won and what their price is. Not everyone else's price, but the winner's price. So if there's any sort of gamesmanship, the disappointed bidders would be able to identify the gamesmanship readily and complain about it. They wouldn't necessarily have a bid protest mechanism, but the concept of sealed bids is the same in the federal grants context as it is in the federal, under the FAR. So very similar process. The federal grant regs do say that sealed bids are the preferred method of procurement for construction. But just like in what I experienced in the federal system, or what I observe in the federal system, even for construction, RFPs are frequently used at this point. Same is true in the grant system. If you want to have a discussion, if you want to negotiate with the offerers, it's perfectly fine to use an RFP in the construction context. Sole source. So if you're over $10,000 and you want to solicit a proposal from only one entity, you only want to negotiate with, you only want to talk to one entity, that's when you're in the sole source context. And again, this is called non-competitive procurement under the uniform guidance. And I already touched on the circumstances where this is authorized. Since 2020, in 2 CFR Part 200, the very first exception, or the very first, I should say, circumstance in which sole source is permitted is when the procurement is under the micro purchase threshold. In my view, this language is essentially just belt and suspenders, because we already had language in the uniform guidance that said under the micro purchase threshold, there is no competition requirements. It didn't really need to be waived, but now it's very clear in this, there's a redundant section of the sole source portion of the regs that says under the MPT, no competition requirement. Item available from only one source. This is obviously the most common justification, and this is really similar to FAR, I want to say subpart 6.3. It's either 6.3 or 6.4, but the only a single responsible source in the under the FAR system. The only language we have under the uniform guidance is that the items available from only one source. That's it. Where by comparison under the FAR, we have a lot of explanation about what that means and when that may be applicable. So that's an area where we get a lot of questions, and I think something like a model procurement code could really elaborate on what's meant by the items available from only one source. I often am telling grantees, use the FAR by comparison here. The FAR doesn't apply to you, but if it's good enough in the FAR, you could probably make the argument under the uniform guidance. Public emergency, the language of the regs is actually public exigency or emergency that won't permit the delay or because of which you can't indulge the delay of the competitive procurement process. So exactly when an emergency is sufficient to justify a sole source is somewhat in the eye of the beholder. One thing we do know is it has to be a public emergency. It can't be your own poor planning, just like under the FAR, it can't be your own poor planning. But if it's a weather event, so FEMA has a lot of guidance in this area. The pandemic was a good example. We had a lot of healthcare entities that we worked with during the pandemic where you may recall in the news, just routine healthcare supplies because of supply chain impacts, but also because of the healthcare impacts of COVID. Routine, rubber gloves, things like that were just very hard to get. We were told by a lot of entities that they had open orders out to anyone who could supply that stuff. And so there wasn't a competition in the sense that they were putting out an RFP. The competition was in the sense that they told everybody who could supply the stuff, if you've got it, send it to me and I'll pay for it. That would be an area where the public emergency of the pandemic would be a very strong justification for the non-competitive payment of probably more than normal for rubber gloves, during the pandemic, for example. FEMA's got, just one moment. So FEMA's got great guidance on what constitutes a public emergency or exigency. And one of the things the FEMA guidance says that I think is very good guidance, but it's not technically in the regs, is that to the extent that you're buying something in a sole source environment or a limited source environment because of a public emergency, you should only be buying that which you need to get you through the period of time that it will take you to go out to bids, to actually use a competitive process to get a longer term contract in place. So get 3 months worth of debris removal, but if you have a longer term debris removal contract or generator contract, only use the sole source to get the immediate need and then start the competitive process right away. Starting the competitive process for the longer term need helps to justify the shorter term sole source. But go ahead, Chris.
On the public emergency exceptions, it was interesting in the pandemic. One of the things looking back at what happened during the pandemic that emerged was the concept of ghost demand. Public buyers, because the regulatory requirements are putting out quote requests from 3 different vendors. And so the vendors thought there was actual demand there. And that was driving up the price, even though only one vendor would get the glove order. And so it was called ghost demand. So in a extremely tight market, like the PPE market during the pandemic, requiring multiple quotes, in fact, disrupted the market and drove up prices because some vendors thought that they had more demand in the marketplace than was true.
That's interesting. One of the things, by the way, to that point, one of the things the regs don't address expressly, but I really think they should, and I think would be a great thing to address in something like the Model Procurement Code, is IDIQ contracts. Because a lot of entities don't realize that's an option for them if they're not involved in federal procurement. The concept that you could get a contract in place that's for multiple years that you can just buy off for a while, and you've got this underlying competition that's good enough to meet the competition standards. And so what you have is local governments just sole sourcing over and over and over again, instead of establishing an IDIQ that's more broadly competed to get better prices in the first place. But it's sort of related to the point that you were making. Had they had an IDIQ in place, you don't need to keep going out to get those fake bids because you just buy off the contract that you've got, assuming that they've got the supplies. There's a justification for sole source that your funding agency expressly authorizes it. That's extremely rare. I've only seen it in the context of CDC with essentially subject matter expert type consultants. They don't seem to have a problem with it, but otherwise it's very rare to get express approval. And then the last justification here, I don't really think of this as sole source, but again, technically in the regs, this is called non-competitive awards. And it would be technically a non-competitive award, or at least be an award without price competition. And that is you solicit from the world, or you broadly solicit and you only get one offer. The regs confirm expressly that that is permissible. You can award to that one offer. They actually don't say, if memory serves, FAR Part 15 says that if you have that situation, you're forbidden from telling the offerer that they're the only one, or at least you're strongly discouraged from telling the offerer they're the only one. That makes a lot of sense because you don't want them to realize there's no price competition. So that's, I think, best practice under the grant regulations, but it doesn't go so far as to actually say that. Technically, under the grant regs, if you purchase through a non-competitive process, you're required to evaluate profit separately. This is not, in my experience, actually really done. And even if you tried to do it, the best you'll do is trying to do it, because the offerers, these are commercial items, they're not going to break down what their profit component is for 2 reasons. One, a lot of times they don't know. They're just charging you with, if it's, for example, services, especially consulting type services, they're just charging you what the market will bear, and they don't actually have a full analysis of their cost structure. That's very common, I think. But also, if they do know, let's say it's goods or it's supplies, it's hard to get that type of information. And so there's a requirement in the regs that I think is really very much unrealistic. I've never seen it enforced, but it is in the regs. And then just like in the FAR-based system, sole sources, you got to document your justification. And so this is a lot like a J&A. It's your memo to file. Except there's no A, I guess. It's just the J.
So Scott, can I ask a couple technical things? One is that we've got a question in the Q&A. Is the technical question about the, once you take a look at it from Kristen, it's a question about increasing the threshold. The other is that, and I'm kind of cheating here because I'm throwing 2 questions at you at the same time. You said that an NFE, a non-federal entity, you recommend that they don't put a bid protest system in place. Section 200.318 says a non-federal entity alone must be responsible in accordance with good administrative practice and sound business judgment for the settlement of all contractual and administrative issues arising out of procurements. These issues include, but are not limited to, source evaluation, protests, disputes, and claims. So they have the option of setting up a bid protest system, but they're not required to set up a bid protest system.
Correct. And I think what they're getting at with this section with 200.318, at least on the bid protests point, is you can't go to GAO just because there's federal funding in the background. You can't go to a COFC just because there's federal funding in the background. It's still a procurement by this non-federal party. Also, if there's a contract dispute, you can't sue the federal government over it. You got to sue the grantee.
Kristen's question is very technical. Do you want to respond to it here, or do you want to ask her to send you an email?
Let's do this. So Kristen's point is a good point. She's saying, look, Scott, actually, if you read the regs, it says clean audits or a couple of other things. I will have to go back to the regs to look at what those couple of other things are, but it looks like, Kristen, you're saying you're actually using one of those other things. Feel free to send me an email. My email is at the at the end of the presentation. You're right. There are a couple of other justifications for raising the micro purchase threshold to $50,000. I don't remember the specific list. I will tell you that my reaction when reading the list every time is I always come back to, well, you better have clean audits because the other ones are really hard to prove. Inherent in your question, though, is you're a state agency. It looks like if you're a state agency, it doesn't matter because you're accepted from the procurement standards in the first place. If you're a local government entity and you're using some other justification besides clean audits, that might be viable since you're a governmental entity. If you're a nonprofit, I wouldn't generally recommend it. But shoot me an email and we could talk it through. You're right. There are some other justifications you can use. I think they're just, my recollection is, and again, I can't remember them off the top of my head, they're harder to document and prove if ever questioned. In terms of documentation, there is one of the things that's, I think, notable in the uniform guidance standards is that in addition to, you always have to, just under the cost principles, costs have to be adequately documented to be allowable. If they're ever challenged by the federal agency, you have to produce documentation supporting the nature of the cost in terms of its allowability and its allocability to the particular project, right, that's funded by the grant to which the cost is charged. So that piece already exists. The piece that really gets layered on in the federal procurement standards is that you're required to keep process documents. So if the procurement was over $250,000, you got to keep your RFP, you have to keep the proposals that you received, or at least the spreadsheet that shows that you received multiple proposals. You have to keep your rationale for who you awarded to and why the price was reasonable. And so what a lot of entities will do is they'll just have standardized forms that they use to document all of this throughout the procurement process. That's true just as a general matter with governmental entities, but even nonprofit entities, for-profit entities that are using federal funds for procurements, they'll oftentimes establish sort of standardized baseline forms that they can append everything to, where they're checking all the boxes on this stuff. That's also true for example, I considered lease versus purchase, just check the box. And you're going to be, generally speaking, in good shape. Local preference limitations. So this is something that I think is I'm not sure why this is in the uniform guidance. I think it's really interesting. But it is, and Professor Chris, you may have thoughts on why this exists, and I don't know whether this existed before the uniform guidance. But one of the things that's expressly in 319 is, and I'll read the regulatory text, but the non-federal entities. So this is the state. Well, doesn't apply to state governments, but local government because they're accepted from the procurement standards. But the local government or the nonprofit or the for-profit that receives the grant must conduct procurements in a manner that prohibits the use of statutorily or administratively imposed state, local, or tribal geographic preferences. Oh, and I should say tribal governments as well. Tribal governments are subject to these rules. Preferences in the evaluation of bids or proposals, except in those cases where applicable federal statutes expressly mandate or encourage geographic preference. And this is important in the sense that, so you can't have local governments love to have buy local requirements. And in fact, sometimes if you have an award from a state where it's state money that's funding the transaction, sometimes when it's federal money, they just don't realize that this is a rule. When the state is funding your project, whether it's, again, federal funds flowing through the state or just state funds funding your project, they'll impose a buy local requirement on you as the subrecipient. This is true for local governments as well. And then sometimes nonprofits just want to have a preference in their policies for local, usually in the case of nonprofits, disadvantaged businesses. And it's prohibited. If you're using federal dollars, you can't have a local preference. You can have a labor surplus area concern preference, but you can't have a local preference. This really matters for local governments. It would matter for states too, except that they're accepted from the requirement. For local governments, it really matters because oftentimes they will have small business preference programs, and oftentimes buried in the definition of a small business concern for that local area is a geographic component. So like in Washington, D.C., for example, I'm fairly certain that the small business preference programs implemented by the District of Columbia, to be a small business concern in the District of Columbia, I believe you have to be incorporated or established. You have to exist under the laws of DC and also be small. And so it's a good example of, you think it's a small business preference, but it's actually a local geographic requirement. That preference, if they're using federal dollars under a federal grant to buy things, that preference would not be legal. And I bet you they implement it all the time in federal programs, but I can't say that I've seen it, but I wouldn't be surprised if the DC agencies are regularly imposing that preference. So you can have Buy America preferences. I have not often seen, until the new federal encouragement for Buy America, I have not often seen a state or local government have a domestic preference, but theoretically they could. This is just a prohibition against state, local, or tribal geographic preferences.
To your question, Scott, I mean, the logic of it might be, though I haven't seen the rationale set forth anywhere. The logic of it might be, look, federal funds are collectively gathered, they're a collective effort, taxpayers across the country. So setting up a local preference when in fact taxpayers from other parts of the country help fund this doesn't make any sense. I think that might be a working rationale.
It could be, certainly. Back. I had a point I wanted to make related to the Model Procurement Code, but now it's slipping my mind on this point.
I can tell you that the practical problem will be the Model Procurement Code reconciling both this issue of no local preferences, but at the same time being able to accommodate the national preferences, the Buy American preferences. We've been working on the assumption here, Scott, that there's only one part of the Model Procurement Code reform, which is actually the code language. Not true. There's going to be reporter's notes. There's going to be background guidance. And if you look at the 2000 version of the MPC, of the Model Procurement Code, there are a lot of policy questions that are lodged in those reporter's notes. And that becomes an important repository for some of these issues that just can't be resolved at the statutory level.
Interesting. And it makes sense. Actually, and I was going to say, to that point, I was checking my email during the break, and I have a question that literally says, we had a state agency come out and visit us as the pass-through entity, where they're subrecipient. And one of the things they told us we had to change in our policies was they wanted us to implement special language in all of our policies that acknowledge the fact that different federal agencies implement programs in different ways. And so to address all the nuances of the different federal programs. And so the email was like, do we really have to do that? Because that's very, very hard to do. But it just goes to show how, despite having a consolidated set of rules, the culture across agencies, everyone is very aware that it's very different. And the answer is, of course, they should not do that. So small business preference and domestic preference. I already talked about the small business sort of soft preference. When possible, you must implement measures to encourage participation by small businesses, labor surplus area concerns, minority-owned businesses, and quote unquote women's business enterprises. So that's in the regs. It's not a hard and fast rule. Most local governments, in my experience, also most state governments, will have programs designed to encourage participation by these types of offerers. There's been language since 2020 that was a soft encouragement to also Buy American. And what the language was, so it's a 200-322, and it was as appropriate and to the extent consistent with law, to the greatest extent practical under a federal award, entities should apply a domestic preference for goods, products, or materials. So as a soft preference, I have never seen it come up through 200-322. I have not seen it come up as a compliance concern. So again, it's a soft preference. But in 2020 and then 2021, we got two hard and fast statutory requirements that impact sourcing in relation to what your supply chain risk and where the offerer comes from and promoting domestic supply chains. And there's sort of one from each end of that, one supply chain risk and the other is promoting domestic sources. We don't have a lot of time, so I'm just going to touch on these, and we could talk actually at length about each of these independently. But what ends up happening with the uniform guidance is that Congress says, look, there's some policy preference we have, and then it gets rolled down to states and local governments by virtue of funding conditions. So if you think way back to the beginning of the presentation, Congress has virtually unlimited authority when it's telling you how to spend the federal dollars that are in your hands and what you can do in terms of spending those federal dollars. So the first thing that they did is back in 2020, or the first big thing I want to talk about was back in 2020, Section 889, this really was implemented in the procurement system under the FAR in 2019, but a prohibition against acquiring equipment or services that have as a substantial component equipment or services that are provided by Huawei, ZTE Corporation, and then with respect to security systems, Hangzhou Hikvision Corporation, have the list in here. Actually, on the next slide, let's just use it, and Dahua Telecommunications Company. So the rule in the FAR is you can't even use that. If you're a federal procurement contractor, that stuff's just got to be out of your facility. If it's a Huawei item, it can't be in your equipment as a substantial component. In the federal financial assistance system, the restriction is a little bit less robust. It's that you can't use federal dollars to procure or obtain those things, but it's still a limitation on buying. So everyone who buys IT has to be aware for telecommunications equipment of the Huawei ban. It's difficult to implement, but it's a good example of the kind of things that you see really impacting the state and local governments and what they've got to manage. Well, I guess it's in this case, it's state governments as well, and what they have to manage when they're carrying out their procurements, when Congress decides that as a policy matter, it wants to limit potential sellers in some way where it then attaches that limitation to the federal funds. I say this applies to state governments because this doesn't actually appear in the procurement standards. The Huawei ban appears at 200.216 and in the federal cost principles. So this goes beyond the federal procurement standards. The same thing's going to be true with the Build America, Buy America limitations that go beyond the federal procurement standards, but they impact procurements. Go ahead, Chris.
No, it's just, I was teaching, so 10 years ago, we talked about the idea of automatic cross-debarment. If you're debarred in the United States, you'd be automatically cross-debarred in Peru. It seemed like a really cool idea as the debarment stuff started to emerge over the horizon 10 or 15 years ago. I was teaching on this, teaching the Huawei ban last week in Vienna, and I had a student from the People's Republic of China in there. We were talking about cross-debarment. He said, yeah, this makes a lot of sense. They said, well, Huawei has basically been debarred permanently by the federal government. Should there be an automatic cross-debarment by the People's Republic? He freaked out. He said, no, absolutely not. So the Huawei ban is interesting because it basically is the final nail in the coffin of automatic cross-debarment, because it's obviously something that other nations couldn't adopt automatically.
You know, interestingly, in the financial assistance system, this idea that basically an entity is kicked out of participation by virtue of Congress enacting a limitation, whether it's through an authorizing act like this was in the NDAA, or whether it's in an appropriations rider that recurs year over year. That's now been litigated twice. It was litigated back, remember when there was several years ago, Acorn got in trouble for some of their practices in their social service programs, or alleged practices. But and Congress got mad about this, and they actually started writing into the HHS appropriation statute every year, and it's still there. No one's allowed to spend federal money on Acorn. And so Acorn sued and said it was a de facto debarment, and they lost. And basically the theory of the court, and this I think was the Second Circuit, they said, well, actually, you did get due process. You got about as much due process as anyone can get. Congress deliberated on the matter and prohibited you from participating in the system. And so if Congress implements these types of limitations through funding restrictions, you're pretty much out of luck. Huawei sued over the Huawei ban. And I I can't recall if I've even read if I've read the cases, but they lost. And so again, I think it's another situation, kind of like Acorn, where if Congress makes the decision that federal funds won't be spent on you, you're going to be in a really bad spot. So these things are effective. I mean, I don't know if they're practically effective. It's very hard for a state government to know if there's, Huawei equipment in one of their systems. But as a rules making I mean, they're effective rules. They're easy for Congress to enforce, or for agencies to enforce if Congress does it. Build America, Buy America is on the other side of the spectrum. It's a domestic preference. And it's a very, very broad-based domestic preference for any federally funded infrastructure. And so historically, there were DOT programs where there was this sort of, and this is actually still the case, but it's less important now with Build America, Buy America. Historically, in a lot of DOT programs and certain other programs, there was this web of various Buy America requirements that would apply to particular items in particular programs. And so a lot of times iron and steel, a lot of times manufactured products, but then the various DOT operating divisions would issue waivers. For example, there's a really broad manufactured products waiver within the Federal Highway Administration, even though there's a statutory preference for manufactured products in the Federal Highway Administration. Well, that web of requirements, while it still exists, has largely now been overcome by the implementation of Build America, Buy America, which is something that is presently ongoing. And under the Infrastructure Investment and Jobs Act, what Congress did is they said for all federal infrastructure grants, there is now a domestic preference requirement. And it applies to iron and steel, it applies to manufactured products, and it applies also to construction materials. And so this is in process of implementation. Chris, we've talked about it many times. We've presented together on it. What happened was basically it was going to become effective last May. A lot of agencies weren't ready to implement it, so they issued public interest waivers that pushed out the implementation date to say November-ish of last year. As of November-ish of last year, most agencies are now implementing it in some form or fashion, and they're issuing other public interest waivers that are applicable, for example, to small grants or small components of projects that are large grants. There are other types of waivers that are available, but Buy America in infrastructure is now an enormous deal, and everyone's trying to get their arms around it. This is going to be, I think, game-changing in the infrastructure context. So, interestingly, by the way, to come back to HHS being different and every agency being a little bit different, to date, HHS has said, we don't do infrastructure. That's not what Congress, even though Congress said that it was supposed, even though the statute is really broad definition of infrastructure, even though OMB has said infrastructure basically means everything, including a renovation to a building, we're HHS, and that's not, our infrastructure is not what they meant in the statute, so we're just not doing this. And to date, that's the case. They've essentially opted out of this without, as far as I can tell, any real authority to do so. So we'll see if OMB makes them do it. But right now, they've said that they don't do infrastructure, even though they issue notices of funding opportunities that say they're for infrastructure. So crazy.
Yeah, the reason that Scott and I are shaking our heads is because the definition of infrastructure is very broad. Not just, it really isn't about just roads. It's about things that build the foundation for the future of America. So for HHS to say per se that they're exempt from the definition of infrastructure seems to run counter to a basic principle underlying the legislation.
Yeah, and it really is amazing. My guess is that OMB will make them change that, but that's truly a guess. I have no inside information on that. It's just so divergent from what everyone else is doing, and I believe it's either the National Endowment for the Arts or National Endowment for the Humanities. I think it's the NEA. This is from memory, so I might be off on this. But one of the agencies that does museum type stuff, maybe it's IMLS, has said that if you upgrade your HVAC system, that's infrastructure. So you have them doing that, and you have HHS saying we just don't do it. We don't do it at all. It just doesn't make sense. So this is for the BABA requirements. I've got a slide in here. I know we're close to time, but the definition of what's made in the USA for purposes of iron and steel, or domestic, I should say domestically sourced, because made in the USA has implications, but domestically sourced for iron and steel, manufactured products and construction materials is defined in the statute. Construction materials, actually in the statute, what it says is the OMB has to issue standards. There's a proposed rule out right now that goes sort of by product, wood lumber versus drywall versus other stuff. and set standards for what it means to be completely produced in the United States. The best guidance, by the way, for anyone who's interested in this, in my view, is EPA's guidance. When I say best guidance, I don't necessarily mean that you'll like what it says, but as far as being clear, differentiating between what's iron and steel versus a manufactured product, talking about what the expectations are at the job site for verifying contractor compliance, et cetera. EPA's guidance is, in my view, the clearest guidance. It's very strict, but it's the clearest. And then required terms. So unlike a subaward where you flow down all the terms and conditions of federal awards into the subawards, in the contractor context, all you have to do is look at 2 CFR Part 200 Appendix 2, and then have a, though this probably won't cause a compliance problem, there are other requirements that aren't listed in Appendix 2 that you really should be incorporating into contracts, but it's a relatively narrow list of obligations that you have to put into your contracts with vendors. And the way the system works is you've got this in Appendix 2 to the Uniform Guidance, you've got this list of potential requirements to put in. And the way the regs are drafted is, if it's this type of contract over this dollar value, make sure to include a term on this. If it's this type of contract over this dollar value, make sure to include a term on that, and so on. So it's pretty easy to implement. What it really ends up boiling down to is you got your Huawei ban, you've got termination for cause and convenience, you've got, you're going to have BABA eventually. I believe they'll work it into Appendix 2. You have sort of a throwaway addition of the clean, I hope no one from EPA is listening, but of compliance with the Clean Air Act and Federal Water Pollution Control Act for contracts over $150,000, which is in every federally funded contract that's large, and I think no one knows exactly what it means, and they still sign the contract, so it doesn't cause problems. And what it really means is if you ever do violate those statutes, it's another jurisdictional hook for the EPA to investigate you. But then you've got, for construction, clauses that really matter. And those tend to be labor standards clauses. So there's misconception around this. And so I'll emphasize it. Construction is a big part of what's federally funded in the state and local marketplace. A lot of times grantees, including state and local governments, will assume that Davis-Bacon requirements are applied to all of their federal funding, and that's not true. The way it works is that if Davis-Bacon Act requirements, so prevailing wage requirements, and then the administrative requirements that accompany those Davis-Bacon requirements have to be incorporated into construction contracts in a particular program, either the authorizing act or the appropriations act that funds the program has to say it. And so there are programs where it says like Davis-Bacon applies. A lot of your DOT programs apply Davis-Bacon. Head Start applies Davis-Bacon. And so you've always got to go back to the statute and see if Davis-Bacon applies. ARA, which was a supplemental appropriation, ARA applied Davis-Bacon. So for those programs that were funded under ARA, Davis-Bacon temporarily applied. And then from Davis-Bacon flow the other labor standards clauses that typically apply in a construction context, like the Contract Work Hours and Safety Standards Act, at least the kickback prohibition of the Copeland anti-kickback statute, et cetera. And that's all listed in Appendix 2. What's not as clear is the fact that Davis-Bacon and all of the clauses that flow from it, really, they only apply if the statute says they apply. A lot of grantees think they always apply if it's federally funded contract. And that's not the case. So I think that brings us, conflict of interest. I will hit this in 1 minute because I know we got to stop. Written standards of conduct. If you're involved in a procurement, you have to recuse yourself if you or a family member has a financial interest in potential offers. No gifts or gratuities except de minimis amounts described in your policies. And if someone writes if you hire a vendor to write your solicitation, they're then prohibited from competing on the solicitation. So it's actually an OCI concept in the federal world that's not described as OCI in the grantee world. And then lastly, there's this nebulous requirement that grantees have to address OCI, but how you address OCI, they don't tell you. And so really this becomes sort of we'll try to identify it and mitigate it through reasonable measures. And I won't get into what reasonable measures will be given that we're at time.
Scott, we're going to be returning these issues in the Tuesday session when we do the gap analysis with Yolanda Williams. So I really appreciate you sort of laying the foundation here for what we're going to be doing on Tuesday. And of course, these issues will be carried into the MPC revision process over the coming years. It's likely that the MPC revision process will focus first on this gap. How do we bring the model procurement code up to speed with what the OMB guidance requires? So this presentation you've given is really invaluable for helping us take that next step. And as always, I'm very, very grateful.
Well, thank you for having me. It was my pleasure to join. I love talking about this stuff, and thanks for everyone's attention on a late evening.
Thanks a lot. Look forward to seeing you all on Tuesday, and have a great evening. Take care. Bye-bye.